I'd like to get started by saying hello and welcome again. This is the Wolters Kluwer What Are the Experts Saying? Blue Sky and Crowdfunding webinar. So welcome and thanks for being here. My name is Jenna Ellis and I am one of the moderators today. With me as co-moderators are John Caliguri and Dan Tatello. And as participants here, if you have any questions during this, during Jay's presentation or any problems, you can actually send a private chat to John. And the way to do that is just right at the top. So select the chat icon, drop down John's name, and just send him a private chat with any questions that you may have. So with that, I'd like to go ahead and introduce Jay. Jay is our expert, and he is a leading contributor to the industry standard publication Blue Sky Law Reporter. Jay's been tracking, analyzing, and writing about state securities laws, regs, policy statements, and interpretive opinions for over 23 years. Jay's work analyzing and summarizing the jurisdiction's most pertinent exemptions from securities transactions, as well as the registration and post-registration requirements for broker-dealers and investment advisors, ultimately led to the creation of our ever-popular Blue Sky Smart Chart. So thank you, Jay. Thanks for being here. Thanks everyone else for being here. And I wanted to welcome you, Jay.
Oh, thank you very much, Jenna. Glad to be here.
Great. So as just an introduction for everyone, this is almost a follow-up webinar, although it of course stands by itself, from a webinar that Jay gave back in December of 2013, which was on Federal Rule 506, crowdfunding, fiduciary standard, and the private fund advisor exemption. So today, we're briefly going to touch on State Rule 506 developments, and those are primarily going to be Washington, being the only state to adopt them. Briefly, then, we're going to move to state development from SEC's proposed Reg A+. And we're going to spend most of our time discussing crowdfunding in the states. And when we say that, we're going to start with, crowdfunding-like rules. So they're not really crowdfunding. They're not intentionally crowdfunding provisions. And we'll talk about the states that have actual crowdfunding provisions, especially intrastate versus interstate, and the use of the Internet, the funding portals being primarily a new way to raise capital. And, of course, throughout, you're going to see a whole bunch of screenshots of our Blue Sky Law Reporter and our Smart Chart. Does that sound right, Jay?
Yes, exactly right, Jenna.
Okay. So let's jump then to Reg D, Rule 506 in Washington. Jay, I understand at the federal level, you talked last fall about Release 33-9458 and how the SEC reopened that comment period. So where does that stand now?
Well, the latest Rule 506 proposal was issued last July 2013, and the comment period was to close September 23, 2013. While the initial set of rules were adopted, the comment period was extended to November 4th, 2013, so that people could comment on maybe their experiences using the new Rule 506 amendments. So after the SEC has taken a review of those comments, the rule is still not yet finalized, but I have heard that there's a possibility of it becoming a final rule by the end of 2014.
Okay. But Washington, then, is the only state thus far that has adopted the federal Rule 506, the Fed version of 506, yeah.
Right. Washington did adopt the already adopted Rule 506 amendments before the rule was open for comment. So, in fact, Washington adopted the disqualification and bad actor provisions as well as the lifting of the ban on general solicitation and advertising provisions. But Washington did want to make clear that they did not adopt anything from the comment period provisions that in Release 9458 that the SEC still has under advisement. So Washington, then, is the only state that has already put their new 506 rule amendments into place, which on the federal level, which Washington adopted, breaks down 506 into a 506B and a C, and you have to mark on Form D whether you're going to be relying on 506B or C, and file the form in Washington accompanied by a $300 fee. Now, I just want to mention that all of the level of detail that we're going to be discussing today regarding these various rules can be found in the Blue Sky Smart Charts. In fact, I think the next slide has an example of the Washington State Rule 506 information.
Yeah, we're looking at the 506 topic in the Blue Sky Smart Chart specifically for Washington State.
Yes, and if you can look in the red rectangle, you're going to see the mention of SEC Release 339458, which is that comment period release that the SEC issued, and Washington's point that while they did adopt 9414 and 9416 on the bad actor disqualification provisions and on the lifting of the ban on general solicitation, they have not adopted anything from 9458 because, in fact, those are still under advisement by the SEC following the ending of the comment period last November.
Okay, great. So with that said then, I briefly want to transition over to Reg A+. And so Reg A+ was an attempt to implement Section 401 of the Jobs Act, which directed the SEC to adopt rules to annually exempt securities offerings of up to $50 million from federal securities registration, correct?
Yes. So what happened basically is Congress asked the SEC to propose a Regulation A rule amendments, and those amendments are now what we know as Regulation A+. Congress specifically asked the SEC to propose Regulation A amendments to, as Jenna mentioned, annually allow securities offerings of up to $50 million to be exempt from registration. The SEC did go ahead and propose what Congress asked them to do, but they went further by redefining what a qualified purchaser is, and in doing that, they pretty much preempted the states from regulating Regulation A+ offerings. So that is a battle that is still going on, and the main reason why the Regulation A+ rules at the federal level are still not yet adopted.
So wait, Michigan then, is the only state so far that has adopted A+ provision?
Yes. So while the federal situation is going on and SEC is grappling with the preemption of state regulation and how they're going to deal with that with the SEC and the adoption of federal Regulation A, Michigan went ahead and took it on as the only state to have adopted a Regulation A+ exemption. And basically, among other provisions, what Michigan requires is that you file SEC Form 1A as a notice indicating your reliance on Regulation A, and you send it to the Michigan administrator with a $100 fee.
Okay. All right, so that's kind of a brief update on the status of Reg D, Rule 506 in the state, and Regulation A+. So let's move then to the topic of crowdfunding. I know it was a huge part of your presentation last fall, and so has a lot gone on since then in the state.
Yes, a lot has definitely gone on. And in response to so many states adopting and proposing crowdfunding exemptions, we've added a crowdfunding exemption smart chart topic so that we can put in all the information for the 10 states that have so far proposed or adopted a crowdfunding exemption. And those states are on the next screen, and they are Alabama, D.C., Idaho, Indiana, Maine, Michigan, Pennsylvania, Texas, Washington, and Wisconsin.
Okay. So we're looking at, and so everyone knows, these smart charts have specific examples from these jurisdictions. And I think next we're going to look at a couple of examples of the state results once you drill down to the individual jurisdictions from that crowdfunding topic on the smart chart.
Exactly. So, for example, Idaho is one of the 10 states that adopted crowdfunding, and I just want to point out an unusual circumstance with Idaho. Most of the 10 states have proposed or adopted crowdfunding either as an act exemption or a rule exemption. Through Idaho, though, it came in as an exemption order submitted by the requester, Tennessee Valley Angel Fund, LLC, kind of the way you'd submit a no-action letter. And the senior securities analyst for the Idaho Securities Bureau issued the exemption order to Tennessee Valley. And that is in the the comment column. Underneath, and this goes for all the states, in the crowdfunding smart chart, we put in a link to the federal crowdfunding rules as proposed. So they're all there. In any state you go into, you can go right to the federal crowdfunding rules and see those. And then in the far column, as true of all smart charts, there's a link that will take you to the answer where we set out or summarize all of the provisions that Idaho required of Tennessee Valley to issue the exemption order for them. So that is, Idaho represents one state that is unusual because their crowdfunding is coming through as like an exemption order, or if you will, kind of a no-action letter request. And I'm just going to mention two other unusual situations. One of the other ones is Maine. Most of the other states have a federal requirement for allowing this crowdfunding exemption, and that is abiding by Securities Act of 1933, Section 3A11, and in conjunction with SEC Rule 147, which allows solicitation only for, you can only solicit investors in the particular state. Maine, as I found out from the securities administrator there, allows their crowdfunding exemption is actually a registration, and it's in line with SEC Rule 504 instead of 3A11 and 147. And they did that so that the issuer can make solicitations to investors who are outside the state of Maine. So that is an unusual factor, how Maine stands alone from the other states in allowing solicitation to be made to investors outside the state because their exemption is coming through Federal Rule 504 instead of the typical 3A11 SEC Rule 147. Finally, I want to mention Pennsylvania. Pennsylvania's crowdfunding exemption is unusual because they're never going to have one. Their situation is basically that, and this is mentioned in the comment column for Pennsylvania, they are waiting for the SEC crowdfunding rules to be adopted, because when they are, the SEC crowdfunding rules are going to be Pennsylvania's exemption. Pennsylvania only added amendments from their latest Act amendments this past fall or past summer, basically adopting funding portal or internet provisions to accommodate the crowdfunding exemption when the SEC rules become adopted. So Maine will not have a state-specific exemption. Maine is going to be piggybacking off of the federal crowdfunding rules when they do take effect. And so that is 3 of the 10 states that have adopted crowdfunding. And I just wanted to point out the 3 that I thought were the most unusual for the reasons that I've mentioned.
Great. So Jay, when you and I, or when we all kind of talked about doing this webinar, one really interesting point and an important point that we talked about and that you brought up to us were several states that had these provisions that may be confused for crowdfunding. So, you know, crowdfunding-like provisions, but they're actually not crowdfunding. So is there, you know, what is the story behind that?
Sure. Basically, what happened there was an organization put together some months ago what they thought was a chart of the crowdfunding exemptions from the various states, and the list in this chart did not coincide with the list that I had from the state documents I was receiving. So those particular states, there's 5 of them, Colorado, Georgia, Kansas, Maryland, and Vermont, which are now on the screen. I actually wrote to the security staff people in those states and got back responses basically saying that those exemptions that were thought to be crowdfunding by this organization and others who may have thought the same thing were not in fact crowdfunding, but were actually pre-existing small offering exemptions that were in place in those states way before crowdfunding was even created. So for example, if we take Vermont, Vermont's Deputy Securities Commissioner Michael Pisak wrote saying that while Maine amended its longstanding small business offering exemption, which is nicknamed a VSBOE, and it does contain some of the attributes of a crowdfunding exemption, it is not a crowdfunding exemption. But he did go on to say that the Vermont legislature has tasked the Vermont Securities Division with authoring a study on the benefits and limitations of crowdfunding, and that report is due January 15th, 2015, at the start of Vermont's next legislative session. So Vermont's VSBOE exemption is not crowdfunding, but Vermont is exploring crowdfunding's possibilities. In the meantime, the crowdfunding smart chart mentions Deputy Commissioner Pisek's comment that this exemption, VSBOE, is not crowdfunding, but I do mention that the VSBOE exemption can be found in another smart chart, which is the limited private offering exemption smart chart. So if you were to think that you wanted to claim Vermont's exemption thinking it was crowdfunding and you went there, you'd see the comment showing that it's not crowdfunding, but it would tell you what other smart chart to go through to claim the small offering exemption that isn't crowdfunding but may serve your issuer's purpose anyway. And then we move on another state. One of those other states was Colorado, and the Securities Commissioner Gerald Rome said, "We view our limited offering registration not only as an alternative to crowdfunding, but a far superior one. I believe that those with whom we have discussed this issue come to agree with us, but I cannot predict what will happen with the state legislature. The limited offering exemption, the limited offering registration, in other words, is found in the registration by qualification smart chart." So the point there is that what people might have thought Colorado had a crowdfunding exemption is not an exemption at all. It's actually a registration by qualification, and more specifically, a limited offering registration, which Colorado has had on its books for a long time and which they consider to be a far superior alternative to even a crowdfunding exemption. So far, 2 states now that are thought to be crowdfunding are actually not. So my point is you really need to read these before you really invest the time and energy to do a crowdfunding thinking that a particular exemption is, and it really isn't.
So the next state then, when we were talking, I almost think of it, by the way, the next state is Georgia. I think of it kind of as a hybrid because they can offer these securities traditionally or via crowdfunding.
Yes, that's correct. And actually, Tom Zagorski, Georgia's Securities Division Director, said that the Invest Georgia exemption, which is nicknamed IGE, is not crowdfunding per se. Rather, it is an exemption from securities registration for small offerings that rely on SEC Rule 147. Now, again, because it's relying on 147, which is also a federal requirement for crowdfunding, you can think that Georgia's IGE exemption is crowdfunding, but again, it's not. Issuers under IGE can't offer the securities publicly so long as they file a notice on Georgia Form GA1, and he says that one way of publicly offering the securities certainly could include crowdfunding, but issuers could alternatively rely on traditional forms of general solicitation or simply offer the securities privately, which would not involve a filing at all. And again, if you were to go to Georgia's crowdfunding exemption in the smart charts, you'd see Deputy Commissioner Zagorski's comment. You'd realize that IGE is not crowdfunding, but it would take you to the limited private offering exemption where you can read the provisions and for claiming that particular exemption if, in fact, you want to do that one. And similar to Georgia is Kansas. And the executive director for the Kansas Securities Commissioner's Office, Steve Wassam, wrote me that although various news media and others have referred to the Invest Kansas exemption, which is nicknamed Ike after President Eisenhower, who's from Kansas, that was actually thought to be a community offering exemption for making offerings in small rural parts of the state. He said, we did not intend or anticipate using the Internet for IKE offerings, which is a big red flag that if they're not going to use the Internet, which is a big part of crowdfunding, it's not really thought of as a crowdfunding exemption. He says that that can be problematic in relation to the federal exemption for intrastate offerings, which are in fact crowdfunding offerings under SEC Rule 147, which is an integral feature of Rule KAR 81521, which is the rule number for the IKE exemption. And again, I'll mention it one more time. You can find the IKE exemption in the limited offering exemption smart chart topic, and also find Steve Wassam's comments in the crowdfunding comment column of the crowdfunding exemption smart chart. Lastly, there's Joy Sakamoto-Wengel, who's Maryland's Assistant Attorney General for Securities Registration, and she said that an October 1st, 2014 effective bill that may have read like crowdfunding to people is actually related to an intrastate small business exemption and not crowdfunding. And that's the point of quoting all of these 5 states is basically it's very easy to mix up what you think is a crowdfunding exemption for a state's pre-existing or act to be existing other exemption for small offerings. So you definitely want to make sure that, like I said before, the exemption that you're going for, if you want crowdfunding, is in fact an exemption that the state officially recognizes as crowdfunding.
Right. So now that we talked about kind of things that aren't crowdfunding but maybe look like it, let's maybe jump back to what is crowdfunding in the states that have passed actual crowdfunding.
Okay, and here's the list of the 10 states that have adopted crowdfunding. Again, remember I did mention a little bit about the uniqueness of Idaho, Pennsylvania, and Maine. But these 10 states have adopted or proposed to adopt a number of the 8 main provisions of crowdfunding contained in the SEC's proposed crowdfunding rules, and I'm just going to identify those briefly. One of those federal provisions is investment advice. Another involves offers and sales, investor limits, commissions, resales, intermediaries, which is the internet piece of it, disclosure requirements, and the annual reports. But please also note that while the states have adopted some of these federal provisions or are proposing to adopt them in the states that have a proposed rule on the subject, they have not necessarily adopted them or intend to adopt them verbatim. Some states are going to or have tweaked them to modify them for the state's purposes. And then in addition, I want to mention that beyond the federal provisions, a number of the states have adopted their own state-specific provisions for crowdfunding that go beyond and are different from the federal crowdfunding provisions. Having said that, as you probably know by now, there's a lot of provisions out there in all these states, and when you take into account all the state-specific provisions combined with the federal provisions that the states have adopted verbatim or adopted with modifications, there's really too many for me to go through in a half-hour webinar. But so I really can just have identified the ones that I've already mentioned. But again, the Smart Chart is all-inclusive. It will contain everything you need to date on what's out there from the states that have proposed or adopted crowdfunding.
So Jay, before we wrap up then, I think, can we touch then briefly on the trends moving forward and specifically touch on the role of the Internet?
Sure. So I just want to wrap up by saying that I know historically intrastate exemptions have not been particularly popular with the securities practitioners because, you know, we know your securities issuers want to make offerings in more than one state for the offering to be lucrative and worth their time. But I'd like you to just be open-minded for the first time to the fact that this is a unique historical trend going on here that's being set by these crowdfunding intrastate exemptions. And basically that's the role of the Internet. Yes, the crowdfunding created exemptions are intrastate, and that makes them like the previous domestic issuer exemptions that the states have adopted. But because the Internet is being allowed to be used for the first time, the Internet will be able to reach a larger and often more middle-class population, and that will increase the potential for your issuer small businesses to successfully raise capital and achieve higher offering proceeds and hence more revenue than they've ever generated before. I also want to mention finally in closing that these exemptions really you should review because one of them just might be right for your particular issuing company. And there's also the possibility that as time passes and these exemptions are out there with real issuers, purchasers, and investors, the states will get feedback back about them, how they're doing. And if they're too restrictive for raising capital, the states will probably relax the provisions. And I do mean the states that already have crowdfunding out there, as well as the states that will in the future adopt crowdfunding. They'll loosen the provisions. They will make capital raising even more enticing for your issuers. So please refer back to these exemptions in the Smart Charts and the Blue Sky Law Reporter as they are tweaked and redefined and as more and more of them roll out as we go through from the beginning of this crowdfunding situation that started just last fall.
Okay, great. So actually, Jay, before we wrap up, I have a couple of questions. Let me pull them up that John sent me from his chat questions. Let me see. Okay. First question, what are the most important crowdfunding provisions?
Well, I'd say that from the get-go, the first one would be eligibility, because you can't claim the exemption if you're not eligible. And basically, because it's intrastate, you have to be an issuer who is located or whose principal place of business, depending on how the state words it. You have to be an issuer from that particular state. And except for Maine, your investors have to be residents of that state. And, of course, you have to rely on SEC 3A11 and SEC Rule 147. I'd say those were important provisions. Another provision that's important is the investor funds have to be held in escrow by an escrow agent that's located in the state. There's usually a notice filing that's required that requires a specific fee. There are investor limits, how much money you can raise from a particular investor. There's consideration and cash limits on the total aggregate amount of the offering. There's some quarterly reports you have to file, and then there's the internet piece. There has to be a funding portal that's pretty much located in that state that the state can kind of monitor as it facilitates the offering for the issuer, and it will have a certain set of internet requirements for the funding portal. There's some advertising restrictions with the advertising you're going to use for the offering. There's a disclosure document that has to be filed and included with the filing and the fee. Pretty much, and there's some resale restrictions, purchaser agreement issues, and finally commission restrictions on the commissions that the broker-dealers can receive when they make the offering. Those are a lot of the main federal combined with the state-specific provisions.
Okay. And I have one more, and that is, let's see, which crowdfunding provisions vary the most among the states?
I would say, well, first of all, the notice filing one will vary because, as with many exemptions, all of them and all registrations, the fee that you're required to pay for filing will vary from one state to another. But moreover, with the crowdfunding, the two things that will vary the most, I've seen vary the most so far in looking at a lot of the provisions, is the total amount of cash consideration that you can use for the whole offering. Some states have a very simple amount. Other states have a tiered approach. And the final one that I say would vary the most among the states is the single investor limits. Some states are very restrictive. You can only gather $2,000 from the investor. Some allow you to get $5,000, and some go as high as $10,000. So I'd say the single investor limits, the total amount of consideration that can be used for the aggregate offering, and then finally the fees for filing the notice would vary the most.
Okay, great. So, John, any other questions that came in while we were answering those questions?
I'm not seeing anything, and I don't have any raised hands either.
Okay, great. So I wanted to thank everyone for coming and participating in our What Are the Experts Saying for crowdfunding and Blue Sky. And as a follow-up, there'll be a really, really short survey link that will be sent to you along with these slides. So you will be getting these slides via email, the email that you've registered with. I know everyone always asks about that. Any other questions, please let me know. And the survey and then any comments or questions directed toward me will allow us to keep doing these and making even better presentations. So again, those will follow via email. And I wanted to thank everyone, really, really, really thank you for your participation today. And then thank you so much to our expert, Jay Fishman, for all of his insights. So thank you very much and have a good rest of the day.